Hey, hey, hey. Welcome, welcome, welcome. It is time for another episode of Ask an Agent. Yes, I am super excited. As you can see, I'm always excited. And again, yes, I chose to wear the red headband that blends in with the red background. But hey, also matches my red lipstick. Anywho, we are here tonight going live, of course. And while we wait on our special guest who actually had a previous engagement, and so it's going to be chiming in from there. But while we wait on our guest to join us, you know how this is. I'm bringing the camera now, and I'm super excited. That's adding.
Hey.
Can you hear me?
Yep, hear you fine.
Great. Your head's kind of cut off a little bit. There we go. There you go.
I got it.
All right, awesome. So today is Ask an Agent, and we are live on Facebook. Ladies and gentlemen, my special guest tonight is a top-notch attorney here in the Charlotte area, as well as in Chicago, for all my people that are from the Chi-Town. This gentleman knows 100% of the information. He's having fun doing what he loves to do, and that's practicing law, okay? He knows all the information. You can ask him a question. Rarely does he ever say, hang on, I'm not sure if I know that answer. Let me find out. He knows everything. I can't say that enough. And he's just an all-around great guy, right? And so at this point, y'all, I want to make sure I can hear Michael good, because he's still kind of fidgeting with his camera. Michael, can you hear me okay?
I can hear you well. I can hear you well.
I can hear you well too. So we're going to go ahead and get started. And so like I was saying, audience, this is how, you know how this works. Every week we do this. You ask us questions pertaining to what the topic is at hand. And so Michael Hoard is actually, a closing attorney. I said he was an attorney, but now I had to be specific. He's a closing attorney, a settlement attorney, the escrow agent, if you will. He does it all. But this gentleman is going to talk to us a little bit about the closing process and what to expect. We're gonna, you know how you do, you got to put your questions in the chat if you have questions. I of course have some pre-questions that I'll start off with, but before we do that, Michael, I always give my guests, Attorney Hoard, I always give my guests the opportunity to tell us a little bit about yourself and how you got here tonight.
Sure. Thanks for inviting me tonight. I don't usually do this, which is why I'm having difficulties. But it's a pleasure to be on. And so I was born and raised in Chicago on the South Side. Shout out to my Chicago folks again. I've been here in Charlotte for about 6 years. I've practiced law. I'm giving you guys like general points. I've practiced laws for about 21 years. Started off as a prosecutor doing criminal appeals in the Supreme Court and the U.S. Court of Appeals and the Illinois Appellate Courts. Went on to go into private practice. Did that for quite a few years. We did family law, personal injury, criminal law, real estate, bankruptcies, you named it. Whatever came in, that's what we took. Sometimes you got to hustle that way when folks won't give you an opportunity. So you just make your own way, as we have done as people for a very long time. And after that, I worked in the corporate arena as trust counsel for a couple of years. After that, I went into private practice again, and I've been in private practice since then. It's been an interesting trip, to say the least. But as I stated, I'm from the South Side of Chicago, and I learned a lot from my upbringing. I've learned a lot over the years just from people, in general. It's been a blast, and I mostly do real estate now. I do bankruptcy. The practice is here, practice is in Chicago, and that's it. Oh, I should mention I have 2 beautiful children and a wonderful wife as well. Yeah.
Look, for those of y'all that was looking at him as eye candy, he said y'all straight up front. I love it. But yes, he does have a beautiful family, and that is why he does this. That is his why. His family is what keeps him motivated each day when y'all getting on his nerves, okay? Nah, y'all don't get on his nerves. He loves what he does. He really does. But Michael, um, we're going to start out with just asking some kind of general questions. But before I do that, I once had you, well, not one time, several times I've done workshops with you, first time homebuyer workshops, where you came and you spoke to the people about home ownership. And you, one particular time, like wowed me with giving the historical background for African Americans. Do you mind just kind of taking us through that?
Sure. Sure. You know, I love to talk about that. That's where my passion lies in this area of real estate. So if we think about it, if you think about, I don't want to take up too much of folks' time, but if you think about racism and how we were held down, and you just think about the holiday coming up tomorrow, the newly formed holiday of Juneteenth, and just think about Black Wall Street and how that was destroyed because we tried to do something for ourselves. Our history is not that far away. It's pretty recent. So we were slaves, we were property, and over time, we were just let out into the world without anything at all, really, to start. We needed to start, and as business owners, we know that that's pretty familiar to us. You know, sometimes we don't have opportunities, so we have to make those opportunities for ourselves. However, specifically within real estate, we were not allowed to buy in certain areas. People hear about redlining, and in certain areas, you just were not allowed to buy as a Black person. And those areas were usually the undesirable areas with, say, smokestacks where people got asthma, or places where trains ran through. The undesirable areas is where you were allowed to be as a Black person in this nation, and it was supported by the federal government. If you think about FHA lending or VA lending, we were not allowed to get those loans. And when veterans came back from the war, World War II, they weren't placed in some of those housing developments that were established. They weren't given VA loans the way white folks were given VA loans. We didn't have that leg up, so to speak, although we did the same work. And because of that, our people were behind. And specifically in real estate, the National Association of Real Estate Brokers, I'm going to send a shout out to the president of the local chapter here, was formed in 1947 because Blacks were not even allowed to be a part of the National Association of Realtors. So you have to remember that we were kept out of any avenue you could think of. Racism was insidious, is what I call it. It was everywhere, places you can't even imagine it was. We were excluded. And as we do, we build our own. So the National Association of Real Estate Brokers was formed because Black real estate agents could not be a part of the National Association of Realtors. And the mission was to support democracy in housing. And the Fair Housing Act that passed in 1968 was supported by the organization, was extremely instrumental in making sure that act passed. And what that act did was it opened up doors for us to be able to choose where we wanted to live, to get equal access to financing as much as our white counterparts did. But the sad thing is that after 50 plus years of the passage of that act, we are still behind in terms of wealth, and we're still behind in terms of home ownership. We are the low people on the totem pole. Nothing has changed, and we need to realize that some of these methods are still in place. They have not changed. We need to be at the forefront of making sure that changes. And I beat the drums everywhere I go about Black home ownership, and that's what's key, and that's what's important. That's the first step to building wealth. There's nothing else. I mean, you can think that you're going to be a famous rapper or a famous basketball player or football player, but there are millions of people in this world. So if you think you that's special, you go for it. But if you ain't got no plan B, you're going to sit and wonder what you could have done differently. And the first step for us is to own your home. That's the first step to building wealth. You build equity within that home. It makes you be able to build a business afterwards if you need to with that equity. And equity is the money that you attain over time when your property value increases. When you have that large chunk of cash, probably the largest chunk of cash most folks will see in their lives. You can take that and start a business. You can take that and send your kids to college, any college they want to, as opposed to them just trying to figure out something else. College is important, and I get on the bandwagon about how college helps people increase the amount that they make per year. I know a lot of don't listen to the noise about, oh, you shouldn't go to college. It doesn't make sense. It's just too much. The loans are too much. It's not going to do you any good. That's BS. I learned so much from leaving my neighborhood to going to a college that helped boost me to where I am today. And it's very important. So home ownership is very important to me. And I do it day in, day out. And I love to see our people succeed.
I am so glad that you said, about going to college. I know that doesn't really have anything to do with home ownership, but it is so important when I tell you that life-changing experiences that you receive just by leaving your town, leaving your community, and going somewhere else having to live with someone you don't know, having to adapt and develop to a culture that may or may not be a familiar entity to you. But college years was the best years of my life, okay? And not because I was wilding out either, okay? But just like you said, I just learned so much. And not just that, the networking and ties and the connections that I made through college. I have friends that I've had literally since my freshman year in college, which was 1996. I know I look like I just graduated last year, but it was 1996 when I graduated high school and started college. So, look, Michael, excuse me, Attorney Hoard, I'm going to be throwing some jokes in here, okay?
Oh, that's cool. That's cool. That's cool with me. And so, hey, let me say this: I'm not a college snob. So some folks get a trade. Trades pay very well. I'm just talking about income. Income. Do not create a reason for somebody to tell you no. Make sure you have that income to buy a house, and it starts probably with college, probably with a trade. I don't want to, even if you go to high school and you finish, you got a great business. You do that. I'm not trying to knock anybody, but it is very beneficial.
Yes, I agree 100%. So, ladies and gentlemen, go ahead and start dropping your questions in the chat, and I will ask them. But I do want to start off with this this question here, because I get this a lot when I'm out with a client, and they go, "Oh, is all of that my yard?" And I'll say, "Well, we won't know for sure without a survey. Why do we even need to get a survey, Michael?"
Great question. Great question. I know I didn't talk about the closing process. I just went in on my Black Power rhetoric, but we could. So people should get a survey. I would always recommend it. It's something that you don't have to have it. The lender does not require you to have a survey. You don't have to get it to complete your purchase. However, you want to know everything you can about a piece of property, and a survey is specifically when a surveyor, a licensed surveyor, goes out and figures out where your property lines are, or where your boundary lines are, and it shows you where your boundary lines are and whether or not, say, your house is where it's supposed to sit based on governmental regulations. So there may be a setback from the front, a setback on the sides, a setback from the back, within which a structure can be built. And if you don't have a survey, you don't know if that place you're about to purchase is violating that governmental setback. That's one piece. Another piece is, what if your neighbor built a shed or something on their property? You don't know if that shed is on their side or your side. It may encroach onto your land. And then there's a whole slew of legal issues that pop up if somebody's encroaching on your land, or if you're encroaching on their land. There's a fence sitting somewhere. You want to know, is that my fence? Is it on the property line? Do the neighbor and I both have to maintain this fence, or is it just my responsibility to maintain it? You won't know that unless you know where that fence sits. Or say you want to do it in addition to your home later. You need a survey. Say if you're in a homeowners association, they require that if you're going to, say, have a pool placed in, if you're going to build an addition, if you're going to put a fence in, actually, they want to see that drawn out on the survey. And a survey has to be furnished in most homeowners association or homeowner associations, so that they can approve what you've designed and what you want to do. And of course, you want to make sure you put stuff on your property line. Now, another part of this is, with a survey, there's certain coverages that you can get with title and insurance. If you have a survey done, you get that coverage from the title insurer to make sure that that is also insured. So if there's a problem or issue that wasn't spotted in that survey, you have insurance. But if you don't get it, you won't have that insurance or that peace of mind. You're just out there in the wilderness.
SOL, in other words.
Yeah. Can we curse?
We don't want that. We don't want that at all.
No.
Another thing that I get all the time is, what all is included in my closing cost?
Okay. Yeah. That's a good one. So closing costs vary. There are quite a few. And so let me back up. This is a seller's market. It is hot out here for sellers right now. So because of that, your closing costs are not going to be the same they were when it was a buyer's market. And what I'm saying is, you may have to make a higher offer than you normally would. Your due diligence fee may be higher. Your earnest money may be higher. And more importantly, the agents want to get paid whatever they say they're going to get paid. They want to get paid that. So if the seller's not going to pay it, sometimes they will require you to pay it. Some agents are saying, some real estate brokers, agents, it's anonymous. Some of them are like, well, we need to be paid up front before we drive you to 50 houses and spend our gas money, and you may not even buy anything. So that has also shifted. So some of that stuff has changed. However, your basic fees, you have some fees from the lender. Your lender may charge you points. They may charge you discount points if they want the interest rate. If you want the interest rate to be lower, they can charge you origination fees. They can charge you application fees. You have to pay for your appraisal. Appraisals range from 500 maybe up to 750. It just depends. And that tells the lender what the property value is. You don't select your appraiser. When the law changed in 2015, all of that changed too because of the crash. They wanted to make sure the lender had control over who was conducting appraisals. Aside from that, you have your settlement fees. There are the lender fees too. Like if you have mortgage insurance, there's going to be a mortgage insurance premium on there. And mortgage insurance, I don't want to go too deep with this, Nicole, so pull me back when you need to. But mortgage insurance is paid because you're putting down less than 20% of the value of your home. Let me make one big point about this because I was just reading some policy guidelines with our organization. And what we found is that most Black buyers get FHA loans. That is a higher cost loan. So it looks great to only put down 3.5%. But if you get a conventional loan and put down 20%, first off, you're building instant equity into your home. And second, you're not paying as much for that loan as you would if you had an FHA loan because you're paying mortgage insurance. So mortgage insurance is a large chunk of what folks pay when they get an FHA loan because they're not putting down that much. So the lender wants their risk to be insured. My argument is that there's no risk there. Why do you need to even purchase mortgage insurance? But these are policy guidelines we try to battle with, try to make things better for us. And it just makes there's no connection between having somebody pay mortgage insurance and the default rate for Black homeowners between a conventional loan or an FHA loan. But I digress. I'm not going to get too deep into policies. And then you have settlement charges, the fees that I charge for doing the settlement, the title search fee. You have your title insurance. Title insurance in North Carolina is regulated, so it's based on the purchase price. So anywhere you go to get title insurance is going to be the same. You get a discount if you have a prior policy, owner's policy for that property. A seller has a prior owner's policy and you get it. And we always find them ourselves in our searches, and then we get a discount. You get a discount for that as well. Aside from that, you have recording fees for the deed and a mortgage. You have other fees from the lender. They want to start an escrow account, so fees have to go into the escrow account. There may be fees for an inspection, fees for your survey. There's a number of fees that go on a closing disclosure, and you will never know the exact number until sometimes the day that you close or the day before closing. So you got to keep that in mind. Don't be upset when it changes because it may change.
Please don't be upset. That's the main thing that I get. You buyers out there, you'll get that initial estimate 2 to 3 times throughout your loan process from your loan officer, and you're calling us every single time like, oh, the numbers have changed, I just be like, look, just sign off. I said, because nothing is official till the attorney looks at it and decides what your final numbers are.
That's right. That's right.
So, Attorney Hoard, we talked about surveys. We talked about things that are included in the closing costs, but you said something in the closing costs that I want to go a little bit further into, and that's that there is a fee to record the deed. What exactly is the deed for people who don't know?
All right, so the deed, if you think about it like this, property, if somebody's giving you property and you're buying it, they can't pick up the house and hand it to you, right? So you need something to memorialize what that is, that transfer, and that's a deed. So a deed shows me who the current owner is and what that current owner is giving, and a legal description is the how do I put it, the most distinct way to describe a piece of property, and that's because a property address, you may have the same property address in the same city, and so the unique thing is the legal description. And most cities who have plat systems, they have a map book and a map page that where your property lines are designed on. That's not, and do not trust those to be an indicator of your boundary lines. It's just the city just goes out and does that. That is not a good or accurate depiction of where your lines are for purposes of a survey. But that identifies that parcel in particular and tells you what the lot number is and all that good stuff. And that's what the legal description does. So it makes it a distinct transfer from the owner that I've already verified is the owner to the buyer, who you may be. And that deed itself has to be recorded with the Register of Deeds. Register of Deeds collects all records of anything that's transferring. And going back to law school with a race statute and all this other stuff, there are different things we need to know in terms of what type of state we're in and what type of laws govern recording of documents like deeds or deeds of trust. Deed of trust is the same thing as a mortgage for my Chicago folks. Here in North Carolina, it's called a deed of trust. The banks have made it easier to foreclose against folks here than it would be, say, in Illinois. And so the deed itself has to be recorded to put public on notice that you now own the property. The fee for that is $26 for the first. Usually it's just $26 because we don't get any more than 35 pages when we're dealing with a deed, unless you're dealing with multiple parcels that could stretch past that page number.
I'm glad you told us what the deed of trust was, because that was my next question.
Okay, yeah. Yeah.
You are on it, Attorney Hoard. You are on it. Let the people know. So now I want to kind of get into some fun stuff, okay, in today's call, because we're almost halfway through. Nobody's really, going with the flow of the show of typing their questions in for me to ask, and I'm just going at the top of the dome. But, Attorney Hoard, I know over the years of being a closing attorney, you have encountered some strange things. What's your strangest thing that you've encountered at closing?
That's a good question. So I'll think about a couple. So one was somebody came to closing and it wasn't the person who it was supposed to be. They tried to fake it and they ran up out of closing as soon as we found out it wasn't the right person or whatever. That's happened. Another time, there's a form in the lender's docs where you identify your aliases. There was a couple in there, and they realized after going through the aliases that the wife had been married before, the husband never knew about it. So that was interesting. Awkward moment. One of those awkward moments you see. Yeah, so there are some interesting moments sometimes. It's not as interesting as my criminal law stuff back in the day, but there are some interesting moments.
Wow, talk about awkward. Now, have you ever had it happen where at closing, everything is there, we're ready to go, we're ready to go, and the buyer or the seller changes their mind?
Yes. Oh yeah. That's happened quite a few times. So and I've gotten calls about folks wanting to sue other people because they breached the contract. So if you think about real estate, there's a contract, an agreement that you enter into to purchase somebody's home. And if either party breaches, then they may be liable to the other party for damages, what we call damages. And in some instances, you may be able to force the seller to sell the property, which is called forcing them to do specific performance. Some courts frown on it if the seller is kind of like, no, I'm just going to stay in my home. But if it's an investment property or an investor, then the courts would enforce that contract and force them to sell. On the opposite end, if you're a buyer and you decide you're not going to move forward, aside from losing your earnest money and your due diligence, the seller could come after you for any other damages that the seller has incurred. If you have no reason, like if your financing went through and everything was fine, you just changed your mind, you just want to breach the contract, then the seller could come after you for damages behind that. And of course, any fees that you've paid are going to go away. Those are just going down the tubes or down the hole. It's happened on both sides quite a few times, and it becomes a thing where either the parties agree to resolve it or they have to go to court and try to battle it out. So,
speaking of agreeing to resolve, what happens when the earnest money is up for dispute?
Oh, okay. So earnest money. Earnest money is changing. It used to be like.
Let's start by telling what earnest money is.
Yeah.
Because
so
North Carolina is kind of different. We got earnest money and due diligence.
Yep. So earnest money is money you put down as a deposit on a contract. Once you have a contract and you set an amount, and you tell the seller, look, I'm going to put this in trust with the closing agent usually, or a brokerage. They're going to hold this money. And I'm going to show you that I'm serious about moving forward with this contract. If I don't move forward with this contract, then I'm going to default and I'm going to lose this earnest money, and you're going to get it. Now, that's the agreement. However, as a settlement agent or an escrow agent, if I'm holding earnest money, the only way that I can release that earnest money is if both parties agree that I can release it. They identify to whom I will release it and where I should send it. Right? If they do not agree about where to send it, then I have two options. People don't understand I got two options. I can let that earnest money sit in my trust account until it's resolved, or I can send it to the courts, charge a fee for sending it to the courts, and let it sit in the courts, and let you guys fight it out in court over who's going to get the earnest money back. Before, so people didn't care about $1,000, right? So since things have changed, people are putting down $10,000 in earnest money. People are putting 30,000. I've seen 50,000 in due diligence fees because it's just so hot and they really want a house. That's what they'll do. It means more now than it did before, when it wasn't a lot and people were just letting it go. But that's what earnest money is. And once you close, you don't lose that money. So once you close, that money is a credit to you on your closing statement. You get it back at the closing. But if I know I'm just giving you general blurbs, but so say if the seller breaches and say, I'm just not going to close, and rightfully the seller should give you your earnest money back. Or say if it was a due diligence period, right? So there's a period in the contract, it's called due diligence period. And by a certain date, you have to let the seller know if you're going to proceed with the transaction or if you're going to cancel it. And within that period, you need to kick the tires. So you need to do an inspection. You really need to have your financing together. You need to do your survey. You need to know you're going to move forward at that point, or you go ahead and move forward and risk the loss of your earnest money. Due diligence money does not come back. Due diligence money will only come back, say, if the seller was committing fraud. So if the seller was committing fraud and they got your money, you have a claim to get your due diligence back. And if you have a great negotiator, like this real estate agent right here, they can probably try to get not negotiate, I should say, like you just talk to them, whatever. You're not an attorney, but they probably get it back for you. It just depends on what mood the seller's in. Even if you're wrong, and sometimes the seller will give you the money back. But due diligence is not refundable. Earnest, it is credited at the closing. Earnest money will be credited, and it's only refundable if both parties agree. And that's the extent of how I get involved with it. If I see an agreement signed by both parties, okay, cool. But whether or not somebody's right is a whole different calculation, and who should get the earnest money back. I'm very long-winded, so you guys probably give me some yes or no questions.
No, it's perfect. It's an hour-long show, so you're just getting us through our hour. A follow-up question was, did he say the earnest money is returned at closing?
Yes, it's credited at closing. That's correct. So if I'm holding earnest money, then you'll see on your closing statement, page 3, section M, I believe. So anyway, you'll see it as a credit in that section, along with the other credits. You get a tax credit from the seller if taxes have not been posted yet. So like, for instance, now folks are getting tax credits from the seller because the seller owned the property from the beginning of the year to say today's date, but the taxes that come out in September, you're going to be responsible for. And when I say you're going to be responsible there, no, don't panic. Your lender usually pay those taxes out of your escrow account. I got quite a few calls like, I got a tax bill. Talk to your lender. There's an escrow. They're going to pay your taxes for you. But yes, the earnest money is credited back at closing, and you see it as a credit.
Okay, awesome. We have another question here. We're finally getting some questions, Attorney Hoard. So this question says, sorry, what is the difference between a refinance closing and just a regular home purchase closing?
Oh, great question. Great question. So some of the fees that you see in a regular purchase won't be there when you do a refinance. A refinance itself, for those who are probably new to the process in general, is when you say you've already purchased your place, you're living in it. And when I was talking about equity earlier and how that can change your life and all that good stuff, you can refinance your home to take that equity out of it. You can refinance to get a lower interest rate to make your payments lower. And refinancing means you go to a lender and say, hey, loan me this amount to pay off this old mortgage that I have, or any liens that I have on the property. We're going to pay that off. Sometimes a lender may see that you have a credit card to Sears or something. I don't even know if Sears is around anymore. Say for $2,000 or something. And they may want to see that paid off because it's hurting your DTIs. We get in a whole discussion about lending and DTIs and all that good stuff. But refinances are done sometimes to pull out equity out of your home, and the fees that you see from the lender should not be as much as you would see on a purchase transaction. Because in that case, usually with a refinance, you're getting a loan of 80% or less than the value of the home. And because of that, you don't need mortgage insurance, say. So if you had an FHA loan where you had mortgage insurance and you refinance down the road, that mortgage insurance is going away. Or say if interest rates were 8% when you purchase your home, for people who are really old, 12%. I'm sorry, season, they remember 12% or 18% on homes. And you want to refinance, and interest rates are at 3%. That's a heck of a lot of savings if you can get your interest rate lowered in terms of what you pay per month. And don't get stuck in thinking you're going to pay what you pay every month and get it paid off quickly. So you see a 30-year term. Heck, I'm getting up there. 30 years for me. Maybe in my future it may not. So I may want to focus on trying to get my stuff paid off a little sooner if I'm going to be here. And you do that by paying more towards your principal. I tell my clients all the time, if you're gonna make an extra payment, make it towards the principal. Let the lender know that's where your extra payment is going to pay it off quicker. But a refinance, the fees are pretty much different for the lending piece. Now, when you get to the settlement charge, it's the same work. Because if you think about it, the same work I do for the buyer on the purchase is the same work I'm doing for a person who's going to refinance. I have to pull the title. I still have to search the title. I have to make sure it's clean. Have to search for liens. Got to get liens ordered and paid off. All that stays the same. So those fees are going to be the same. Recording fees are going to be less. It's going to be $64 for a deed of trust. You don't have to do a new deed because you've already done it. Title insurance, you still have to pay for title insurance for the lender. Every lender wants you to get title insurance to insure the lender so that they're protected in a number of ways. You don't have to get owner's insurance anymore. You don't have to pay for an inspection anymore. So generally the fees are going to be less. But yeah, I talk too much. I told you.
Not at all. I told you, this is a whole hour show. We are halfway at the halfway mark of the show. So I am going to take a second and recap to all of our listeners what's been going on. This is Ask an Agent with attorney Michael Hoard, longtime closing attorney here in Charlotte as well as in Chicago for my Chi-Town people. We're just asking some questions about settlements and earnest money and trying to make sure that we understand the whole process when it's time to go to closing so that we're not out here looking crazy and feeling like someone has taken advantage of us, because I get that a lot, okay? So I said, hey, you know what? I'm going to bring an actual attorney on the show to let y'all know what the really real is. And that's all Attorney Hoard has been doing. He gave us a little historical backdrop at the beginning. So after the show, you can definitely go back and watch the beginning if you missed that. But ladies and gentlemen, you all know the show does not work well without your questions. So always just put your questions in the chat box and we will get those and address those one at a time. Okay? So with that said, Attorney Hoard, the next question. And this is a question that I just kind of wanted to know about because I had it happen with another attorney where we got to closing and then the seller for some reason didn't realize that they needed to bring $20,000 extra to closing and we couldn't close. How often do you see something like that happen?
Yeah, I've seen it happen, and I figure out which way I want to go with it. So this So even if the seller has to bring money to closing, unless there's an agreement between the buyer and the seller that if the seller has to bring money to closing, that the seller can cancel the contract, that agreement does not stand. If there's no agreement to that effect, the seller has to move forward. If there is no contingency that the seller does not have to pay funds at closing, then the seller has to move forward. So years ago, in Chicago especially, I did, when the crash occurred, I did quite a few short sales. And a big thing was, sellers could not close without bringing money in. So because of that, we had to get permission from the lender to accept a lower payoff amount to make sure a deal can still move forward. And in those days, the contracts that we drafted made sure that we made that understanding that the seller needs to bring nothing to closing in order for it to move forward. If they have to bring anything to closing, then the seller has the option to cancel the contract. That's not the case now. So the standard contracts that you guys use, that's signed off on by the North Carolina Bar and NCREC has approved for use by agents, and all agents can do are fill in blanks. They can't actually draft contract terms. We do. If they have to bring in money, they still have to close and bring in that money. And there was a question about whether or not I recommend a buyer have their own attorney. Should they? Let me talk about. Let me preach about that.
And I want to address that question as well. So
you want to go first? Or you want me to?
Well, I was just going to say, typically the buyer is the one who picks out the attorney, with the exception of new construction. In new construction, the seller, which is the builder, is the one who's picking out the attorney. Now, can you still go and get your own attorney? Yes, but understanding that there are credits that they're giving you back for using their attorney that you would not get. Your answer.
Okay. All right. So I don't want to like go against you on your show, but we about to have it out over this right
Come
here.
on, let's have it. Look, we're gonna learn, okay?
No, that's fine. So this is the thing, and I'm honest with folks. You know, I'm not thirsty for business or anything, so to speak. So I will be honest with people, and I will talk myself out of money all the time. It's all good with me as long as folks can get to where they need to go. So number one, buyers in North Carolina are entitled. There's a right to choose your own attorney when you close, right? So it's a right. So anytime somebody's trying to take that right away from you, you should question why, right? Why would somebody not want me to choose my own? Why do they want me to use theirs? It's just ask those questions to yourself when you're faced with that. And so what you will hear from builders is that, well, we want you to use our attorney because it's just easier. You know, I mean, what sense does that make? How is that easier for you as a buyer, for the seller to use their own attorney? All attorneys have to do the same darn thing. We all got to pull title. We all of us got to make sure it's cool. So what's being done that's easier for you than what the law requires? I'm just gonna throw that question out there. So what happens, and to Nicole's point though, I will agree on this point. If a builder says, well, look, first off, when you're negotiating, and I tell agents this all the time, if they have a preferred attorney, that's one thing. So if you get them to sign off on that contract, right, and then you change attorneys and there's no provision that says you have to go with a particular attorney, you can choose whatever attorney you want to at any time. However, if you agree in a contract, and they're starting to put this in the contract to try to exclude folks like me, if they say you must use X, Y, Z, and you sign off on it, then you need to use X, Y, Z, or you've breached the contract. That's the next piece. The other piece is when you're dealing with builders specifically, where their language is not in the contract, and they say they want you to use their attorney. Here again, they may entice you to use their attorney by offering you discounts. Here, ask yourself this: are those fees hidden somewhere else? So if they're going to give you a discount on your attorney's fees, which may be $100, $200, whatever, and I'll be honest, I charge $850, right? So if they say, well, okay, we're only going to charge you $350 for your attorney's fees, and they hiking up something else, they charging you by $1,000. It really doesn't matter, right? So if it's going to be the same amount there, it's going to be the same amount. But if you're going to get an ascertainable discount from using their attorney, you go right ahead. If you're going to save money, use their attorney. I'm fine with it, you know. But if you're not saving money and you have this right, you need to exercise it. That's all.
Y'all hear that? Did y'all hear that? You have the right, okay, to your own attorney. Buyers pick the attorney. I just said that. Yes, Michael. Good job. We have another question though. What is the definition of eminent domain in layman's terms, please?
Oh no, y'all break it down. So eminent domain is a thing in the law where a governmental agency, federal government, state government, city government, and it depends on what power the city has, is given to it by the state. And I know here in North Carolina, Charlotte does not have as much power, say, as Chicago does in Illinois, but they can come in and say, we're going to take your parcel. So eminent domain is a taking of property, if you will. And in law, it's allowed as long as the person receives a reasonable compensation for that property. Now, and I've had quite a few clients who've had places where the city has come in to take, say, even 10 feet just to build a sidewalk or something of their property through eminent domain. Or they take the entire lot. And some slick stuff that happens when they take the entire lot just to give it to a developer or a private entity. And in law, what we learned is the city is supposed to take land for public purposes. So the trick, and what's happened over time within the Supreme Court, which is why it's important to vote, is that that's been eroded. So cities are allowed, if they see a net benefit from, say, taking your parcel and giving it to a developer where they'll get more tax dollars. It could be a public interest in that, but they have to give you a reasonable value for it. Now, if the city offers you, say, $5,000 for this parcel, and you think it's worth more than that, and guess what? You need to get an appraisal done to figure out how much that parcel is actually worth. And then there's a whole appeals process the city outlines for you, or the state would outline for you. The federal government has outlined where you can appeal their valuation. It's very difficult to get them to not do it. It's possible, but it's difficult. So you kind of want to deal more with the price that they're going to give you for it. If you know some nefarious stuff is going on and you need to challenge it, you need to file an action in court to stop the eminent domain. It's no entity is above the law. So if you need to stop it, you can go to court to try to stop it.
No entity is above the law.
Yeah.
I love that. That means Michael Hoard will fight for you, okay? If it's within his power, he'll fight for you.
Oh, you're going too far now. You're going too far now.
All right, Attorney Hoard, next question. And this one has to do with wills. All right. So I own my home and I pass away and I don't have a will. What happens to my house?
Oh, good question. Good question. So this area right here is a headache. And I'll tell you guys, I charge extra if somebody is purchasing, say, from an estate. Let me define terms. So a will is where you set forth your wishes of what you want to do with your property when you pass away, right? And so if you have not, say if you died and you didn't have a will, guess what? The state has a will for you. And it's codified in law. So that the state states who gets what and how they get it. Now, the difference is you have to establish that in court, which means it's going to be more money, of course, for you than, say, if you had a will where it could be designated. But if somebody has to file a probate action in court, all your creditors have to be satisfied first. And then, your heirs will take title, but that has to be established in court of who your heirs are through a probate proceeding. And you have to start in the state to get that done. Even if you have a will, you have to start a probate proceeding. However, in North Carolina, the law is that heirs take title upon your passing. So they automatically have title to it. If they've been named in a will, I'm already titled to it. There's no question about it. If there is no will, then we got to figure out who's supposed to get a piece of this. So if you hate it, Joe, your son, or Susie, your daughter, whatever, I'm just picking names, then you need to make sure if you don't want them to have nothing, you better put it in the will, because if you don't have a will, they go get their share of whatever's there, and that's the way it works for that. And in terms of the house itself, like I said, it has to go through probate court, and you figure it out that way. But the best way to protect your property and make sure that you don't have to deal with the probate court with that process is if you have it in trust. I mean, a lot of people put places, especially investors, into their LLCs, and there's ways to provide how that will transfer. The company owns it, not the individual anyway. So if you die, it shouldn't impact what happens to the property. The corporate documents would dictate what happens to the property. Or say if there's a trust, you place it in trust, which is a whole separate entity that holds property for you. And when you pass away, it triggers the next trustee. So whoever's named as a successor trustee takes over, or if there isn't another one named, your beneficiaries then become the people who take care of what the trust says. So the trust says, I want this property sold and these proceeds dispersed to XYZ. That happens automatically without the law being involved, without probate courts being involved, because the trust itself as an entity owned the property.
Oh, this is good. You are just kicking us with this knowledge.
Areas of law, they all kind of go together a little bit, but yeah.
Yeah, absolutely. So we're going to jump over talking to HOAs, because we have someone who has asked, what's a restrictive covenant?
Yeah, so good question. Restrictive covenant is, so if I own property, I'm supposed to be able to do whatever I want to with my property, right? So if I wanted to restrict how people use my property when I die or in the future when I sell it, then I will do a restrictive covenant. A restrictive covenant can be anything like, you can't paint the house purple at any time. If you build up on this land, it has to be at least a structure of 2,000 square feet or more. Those are examples of restrictive covenants. What it does is restrict your use of the land is what it does. So it tells you exactly how the land can be used moving forward. And when you talk about homeowners associations, what that is owners have gotten together, or usually the developer decided to create this restrictive covenant that formed an organization really to take over the common areas of wherever you stay. So you have multiple units within one subdivision, then a homeowners association is created and crafted, and all the owners in that subdivision are the ones who are part of it. So the biggest thing is people always act like HOAs are somehow divorced from them. No, you're a part of it. It's your HOA, you're an owner. If you're a tenant, that's a whole different thing. You're not a part of the HOA, the owner is. So if you're not going to be active and be a voice in what you want to see change within your community or with the HOA, then a small set of people are going to be making those decisions for you, like your HOA dues, the restrictions on if they're going to approve a new pool you want, if they want to do XYZ. You allow those small few representatives to do all that for you if you're not going to be a willing participant in what you own. And so owners are able to restrict the use of property. Now, back in the day, another tool that they use to keep us out of home ownership is to restrict us. This house should not, and I found quite a few old restrictions where it says that this house shall not go to a Negro. This house should not go to a colored person. This house should not be sold to a Black person. And that was a standard in most of Charlotte, North Carolina, and the South, if you think about it, is where people lived. Now, we weren't always segregated. There were little tricks that were done to keep us segregated and think that our fights were not common. When you talk about poor people, we can go, let me get off the soapbox. Anyway, restrictions that restrict race now are illegal. It was found so by the Supreme Court. So if you see a restriction that talks about race, it's not valid. It's just not valid. It still sit there, but it's not valid. The way you get restrictions removed, so I'm giving y'all a whole lot of information today for free. The way you get them removed is the folks who are owners have to agree to remove them. And then a different document is done and recorded to remove the restrictions. If there are restrictions and say folks have passed from the original ones, they're the ones, as an owner, you can, with other owners, or remove those restrictions if you need to.
So in a deed that has restrictions like that, and I'm the new owner, I can get that type of restriction removed as a new owner, or I gotta still revert back to the previous owner?
You have to revert back to the previous owner to get them. The original person who was the grantor of the restrictions would have to be the one that removed them.
Wow, unless they have passed away.
Yeah, I mean, if they pass away,
so
courts are very interesting. So courts don't like the restraint on the transferability of property. And if you have restrictions and you want to challenge them in court, you can challenge them in court and ask the court to remove them because they're restricting your use of the property or the movement of property, if you will.
We do have another question that goes back to talking about the wills. It says, does a will have to be filed with?
No. The will has to be when you do an estate. This is if you're transferring property. Really, we're talking about real estate. So if you're going to transfer real estate, and there's a will and somebody passes away, there's not a trust, there's not an incorporation, you have to do a probate action really to move forward. There's an exception. I don't want to talk about the exception, so we just talk about probate. But you have to publish the will and the probate. You definitely have to do that because it identifies who the heirs are. So it has to be attached to the probate case itself. It does not have to be recorded with the county when you execute it. If you're going to do a will, make sure it's safe and secure where somebody can find it. And if you have somebody you trust who you're naming as the executor, you kind of want to make sure they have a copy too. You don't want to give copies to beneficiaries though. You don't want to do that because then they'll come up missing probably if they don't like what's in them. So don't do that.
That was funny.
I wouldn't even try to tell a joke. I was missing.
I know you handing them out to recipients of mail, like they're like, hold up, something ain't right. I'm not getting anything. Why don't you give me this piece of paper?
You'll give me this funky old beat down car. What the hell? Anyway.
They'll take you right on out. Now, Attorney Hoard, you've been doing this a while. You've seen a lot of things. We talked about surveys, we talked about wills, we talked about restrictive covenants, eminent domain. We talked about a lot of things on tonight, and your knowledge, the wealth of knowledge that you have just been pouring into us. I can't thank you enough. It is, because people on the call, I want you to understand, you're supposed to be paying for this. Okay? So Attorney Hoard is doing us a favor, giving us this info.
This is gratis.
Pick his brain, if you will, to get our questions answered. But he's excellent at what he does. Definitely, if you need to reach out to him, you can do so. How?
Oh, you can reach me. Let me think. So my phone number, my office phone number is 704-954-8094. You can go to hoardlaw.com. If you need to send us a message, you can do a contact. There's a contact form right on the website. You can email us at admin, ADMIN, at hoardlaw.com. So those are the three methods to get in contact if you need anything within the real estate realm. I'm very limited in what I do, so don't be shocked if I try to, refer you to someone else.
I'll refer you.
I don't do. I've done quite a bit, but I just don't have the time or the resources to do as much as I used to do.
Now, if a person is trying to sell a house themselves for sale by owner, do you recommend they consult an attorney?
FSBO, huh?
Clearly not consulting a realtor.
Yeah, a FSBO. Well, I would recommend them consulting a realtor because every time I have them call me, I'm like, I know you're trying to save money or what have you, what they're trying to do, but sometimes they end up paying more than what they're saving if they don't know what they're doing. But if somebody chooses to sell their house on their own, they have somebody, say even a family member or somebody else that they have, they can buy it, and they don't need a realtor, so to speak, then they can do it on their own. There will be fees. This is the thing. Who's going to do the contract? So if you're calling me to do the contract, there's a fee for me to get involved with even giving you a contract, not necessarily getting engaged in negotiations or discussions, because that may be cost prohibitive, but just to give you a contract so you can execute with the other party. And then that's all I would do, because the buyer gets to choose who the settlement agent will be. So if the buyer then chooses me to settle it, then I'll settle the matter and close it out for them as well.
Okay. Y'all hear that? So he will represent you for FSBOs. just to do the contract though.
Yeah, contract, and then I'll close it out at the end. Yeah.
The end. Otherwise, call your real estate agent. I'm always available. Okay.
There you go. There you go. Get a real estate agent. Figure it all out.
That's right.
Another thing, I want to tell your folks, don't be fooled by these big box operations coming in, trying to tell you don't need a real estate broker or an agent. Don't listen to that. They're sticking you in the end. And I know the tricks that they're pulling to say, well, we inspected, we need to decrease it by this amount or this amount. And sometimes you're not getting honest value for what your property is from somebody who knows the market or who's involved in it. So keep that in mind. Shout out to the brokers. There you go.
People always got our back. Well, listen, we're going to go ahead and kind of wrap it up. I don't see any more questions. Oh,
there was one about a POA. I think I saw pop up.
Buy a house for someone if you have a POA.
They say purchase or sell?
Can you buy a house for someone if you have POA?
So it depends on what powers the power of attorney get. And a POA is a power of attorney for those who are listening. And what that does is it's a part of an estate package too. When you think about it, when you get an estates package done, you want to do a will, a trust, a healthcare power of attorney, and a general power of attorney. What a general power of attorney does is it gives somebody that you trust, whom you trust, power to act as you. So certain powers you give them, and there's certain powers you can limit. So if one of those powers is to purchase property, then yes, they can purchase property with a POA. One of those powers is to sell property, then yes, they can sell property with that POA. The power of attorney has to be recorded. If we're going to see it on a deed, it has to be recorded. I'm able to rely on it. If it's fraudulent, then that's on the person who's bringing it to me. I'm not required to sit up here and do a million questions and do a big old investigation into whether or not somebody's tricking somebody. I will tell you this though, if somebody does not have the mental capacity to execute a power of attorney and say, we're notarizing and we see that, we will not do it at all. I had one instance real quick. I had somebody want me to go to a nursing home to get somebody to notarize a POA. So I'm thinking, okay, you pay this fee, I'll do it. But they better be they better be of sound mind when I get there. The person can hardly talk and hardly move. I'm like, oh hell no, I'm not. My license is way too valuable for me to try to be involved in fraud. So if I see fraud, I'm stepping away from it immediately. I'm just going to put that caveat out there. But if you've been given the power, somebody signed that power of attorney when they had a good mind to do so, and you have the power to do whatever, you can do that. While they're living, it terminates when they die. So keep that in mind.
It terminates when they die.
Or sooner. If they've decided to make it terminate sooner, there's a date that they put in there. It could terminate. It terminates whenever they state is going to terminate, or upon death.
And when you have someone who's signing for you at a closing, so for example, I'm buying a house and all of a sudden it's on a day that I'm in California, I can't sign. I want to give POA to my sister to sign for me. The POA has to be very specific, right?
Good question. Yes. So it has to be specific, and it has to deal with real estate. The real estate parcel that you're purchasing specifically is what we limit it to. And your lender has, if you have a loan and you're getting a loan, your lender has to approve it. So we have to get the form prepped. We need to know as soon as possible. We have to get it over to your lender for approval, and then you'd have to sign before a notary public. And then we have to record that power of attorney and reference it in the deed. If there's a seller giving up a deed, if not, then we record it, and then that person signing all your loan documents at closing.
And then my last question is, what if someone is purchasing cash? What's different with their closing versus someone who is getting a loan?
Oh yeah, cash is easy. Cash is still king. So think about it. A loan, they want you to sign 100 pages. I had one 120 pages today. The other one was like 79. One was 60. Another one was like partially online. So it was probably about 30 some pages. Anyway, it's quite a few documents when you're dealing with a loan. You're dealing with cash, it's straightforward. The seller signs most of the documents in the cash purchase. The buyer, I'm starting to do buyers electronically because it's just, you're giving up all of this cash. There's no question you're buying the place, right? So buyer is fine on a purchase cash transaction, but the seller still has to execute the same documents. It's the same stuff for the seller, it's not the buyer.
Okay, awesome. Any other questions from our audience out there? You guys have been doing a great job giving us all these great questions to ask Attorney Michael Hoard, and he has been doing an excellent job giving us these tidbits, these answers to make our lives ultimately better when we're going to the closing table as a buyer or as a seller. Attorney Hoard, again, I just want to publicly thank you again for blessing us with your presence on Ask an Agent. We do this show once, twice a week, every so often, just as people want to get on here and chit chat with me and laugh it up. And, but mainly it's just so people can get on here and ask their questions live and get the answers and feel like they're getting told the truth. Because I'm real big on that, the truth. And there's so much online.
Yeah.
But we want to make sure that we're getting them the right information so that they can make the best decision for themselves. So again, I do thank you so much for your time. But ladies and gentlemen, that is our time. We're about 3 minutes before the 9 o'clock hour, and I always want to be conscious of your time. Attorney Hoard told us how you could get in touch with him. I'm going to tell you how you can get in touch with me at Coles Keys on Facebook and Instagram, and Coles Keys LLC on YouTube and Twitter. You can always visit my website, coleskeys.com. This has been a great, phenomenal Ask an Agent. We'll see you next time. Thank you so much.
Thank you. Bye-bye.